Hello and good afternoon, good morning, wherever you are in the world. I am Tim Hewson. I am now, for the first time, introducing the Legal Wills live stream. I'm going to introduce myself first. Tim Hewson, one of the co-founders and the CEO of Legal Wills, the company. We operate a will writing service online in Canada, the US, the UK, and now in South Africa. And we've been doing it now for over 20 years. Now it's our 25th year of offering this service. So the purpose of this stream is to answer any questions that anybody has about Legal Wills as an organization and writing a will, partnering with a will writing service as well. I'm happy to answer any questions that anybody has. Please put those into the chat. I did also present recently, just a couple of weeks ago, to a webinar for Charity Village in Canada. There were a ton of questions that came in on that webinar, and we didn't get to all of them. So the purpose of this live stream now is to address some of those questions that I didn't get to. So I want to start with a bit of a background, a story about Legal Wills before we get into those questions. How did Legal Wills start? So back in 2000, myself and my co-founder, Henry Raud, we're still the CEO and CTO of Legal Wills today. We've worked every day for the last 25 years together on this business, and maybe one day we'll get Henry onto the live stream as well. But 25 years ago, we were working in high tech for a company called Nortel. People in Canada of a certain age will remember Nortel and the story that goes with that. But at the time, Nortel was a thriving company, but we used to go out every Friday after work, and a group of us would have regular drinks. And one time we all went out for our regular weekly drinks, and somebody around the table said, "You know what? I don't have a will." And everybody kind of looked at each other around the table, and we all had jobs. Many of us had children. We had responsibilities. We had houses. Everybody around the table knew that a will was important, but we went around that table and not one person in those 15 people had a will in place. So that set off some warning bells with us. We realized there's a problem here. There's a fundamental problem where every single person around the table knows that they should have a will, yet not one single one of us has taken the steps to do it. It's not made it to the top of the to-do list. So it got us thinking, like, what are those barriers? Why are people not writing their wills? That was the start of our Legal Wills journey. We looked at that time at will kits, blank form kits that you could buy from Staples. They were even advertising on the TV back then. We realized that they weren't a good approach to preparing a will. So with that, we decided there's got to be a better way. We've got to look for a way of putting that service in the hands of people, removing the barriers. And those barriers were cost, a convenience factor, just the whole hassle of learning about wills and meeting with a lawyer. We set about trying to remove those barriers. And here we are 25 years later. We've adapted the service over the years. We think we've made it better and better and better over the years. We still have a backlog of work items that we want to do to make the service even better as well. So that's the origin story of Legal Wills. We're still working on it. We're still trying to improve the service. We're still trying to remove the barriers and address the needs of more and more people. I think it's fair to say that when we first created Legal Wills back in the early days, it was a simple service that addressed simple needs. I think over the years, we've adapted it. We've elaborated on what it can do. We've made it better and better. So it does address the needs of more people. There's absolutely still a place for lawyers, legal advice, advanced estate planning. That works for a lot of people, but Legal Wills also works for a lot of people as well. To date, here we are 25 years later. We've created over 500,000 wills. We've done over 1 million documents in general, and that includes not just last will and testament, but a financial power of attorney, a living will, like a healthcare directive as well. So now we've done over 1 million documents. One of the things we really pride ourselves on at Legal Wills is demystifying it, answering people's questions, because wills are typically written for the first time in a person's life. They know they need to write a will, but they have a lot of questions. They don't know anything about it. They don't know what an executor is, what a power of attorney is, what a beneficiary or a bequest, and you use all these terms. What's the difference between a trust and a will? So we're trying to make this information available to people as well. And that's led us to this live stream. We want to answer people's questions. And if anybody has any questions, they're not sure about the approaches to writing a will, they've read something about wills. There's a lot of information out there on the internet that may or may not apply to where you're living. But if people need clarification about something they've read, whether it applies to them, I'm more than happy to do my best to answer the questions. I will preface this as well by saying I am not a lawyer. I'm not going to give anybody personal advice for their individual situation. I can answer a lot of questions about wills. I've been doing this for 25 years. I've received a lot of questions over the years, tens of thousands, probably 50,000 questions about wills over the years. I've seen the questions coming in. I do know about wills, but I need to preface all of my answers by saying I'm not a lawyer. I'm not an estate planning attorney, so I cannot give anybody legal advice. So with that, I'm going to some of there are some questions that are coming in as I'm speaking. I do have some team members. Thank you. I see Darcy is handling some of those questions that are coming in. One of the questions, the first question that came in is, if you use an online service, let's talk about the online will process. What's an online will? And what does it mean when you write a will online? Our service is online. What we're going to do is guide you through the process for answering the questions pertaining to your situation. That's all we're doing. And then at the end of that, we're going to compile the answers to your questions and compile that into a document that is going to be a will that's appropriate for your jurisdiction. It's going to be different for every province, territory, the state, the country. It's going to be different. And we're going to take that into account when we're compiling that document. But for most jurisdictions now, once you've completed that and when you see your will online, you're then going to download it. And we allow you to download that document as a PDF file or as a Word document. Once it's downloaded, for most jurisdictions, you then have to print it and then sign that document in the presence of any two adult witnesses. And that physical piece of paper is your legal will. What's interesting about that is that that was the way it was always done. Since the law of 1837, that's the way it's always been done. That was the law for preparing a will. It had to be printed, it had to be on a piece of paper, it had to be signed in ink. But we noticed what happened is 3 or 4 years ago during COVID, that wasn't practical. We couldn't meet with our witnesses. It wasn't possible. We couldn't even leave our houses at one point. So there were laws that were changed during that time to allow virtual witnessing, like allowing you to witness your document, sign your document, and have a witness over a video call like this, and they could then watch you. You send the document to them in the mail, then they could sign it. They could then send the document to another witness. They could sign it, send it back to you. So you didn't actually all have to be in each other's presence. Not a very good solution. It was very convoluted. There's the same document going around. But some jurisdictions then jumped on the idea of electronically signing a document. In Canada, one province, BC, British Columbia, allow you to electronically sign your document and electronically store your document as well. It's a much, much, much better solution than printing it and ink signing it. which if there's a house fire, you've lost the will. Your family can't even find the will. So some provinces in Canada, one province in Canada allows you to electronically sign and store the will. About 6 states in the US allow you to do it. In the UK, they are now discussing this as a new law, and it's probably going to come into legal effect in the next year or two, where you can electronically sign and store your documents. So, super long answer to, can I download the will? Yes, absolutely. In most cases, you need to download and print your document to make it a legal document, and then sign that in the presence of 2 witnesses to make it a legal document. You then store it somewhere safe, in your bedside table, in your filing cabinet. Just make sure your executor knows where it is and they have access to it when they need it. So how can you have a standardized will given that each province has different issues? Absolutely. 100%. Because what happens is when you come to a service like ours, the very first question you answer is, where are you? Where are you living? Our service is customized for every province and territory in Canada, including Quebec. Is actually a bilingual service as well. And what's interesting is not so much the will. It's more the financial power of attorney, and certainly the healthcare, the living will, the medical directive, that's different for every province in Canada. So the very first question you answer when you step onto our service is your name, your email address, where are you living? And secondly, also, we can get to it, where are your assets as well? And that's going to determine the documents that are going to be created for you. So with that, there's lots of good questions coming. I didn't know all these questions that were going to be coming in. So I wanted to address some of the questions that came in during the webinar that I held a couple of weeks ago. And what I can do is actually run those questions at the bottom of the screen. So we made our will, power of attorney, 20 years ago with a lawyer's help. Cost us a lot of money. Nothing's changed for us. So should we renew these documents, or is there any kind of expiration date for a will or for a power of attorney? The simple answer is no. If you've written your will and you've signed it, the witnesses have signed it, and you've put it away, that is a legal document and will continue to be a legal document until the day that you die. There's a couple of caveats there. In some jurisdictions, if you get married, any previous will is automatically cancelled. Unless the will was written in contemplation of marriage, and it says, I am writing this will, I know that I'm getting married, but I'm writing this will and I want this will to still be in effect after I've got married. You can write that into a will. But for the purposes of this question, this will is sitting in a filing cabinet and nothing much has changed in this person's life and they haven't got remarried, then that will is still going to be in effect for the rest of their life. If you get divorced, the will is actually still in effect, but in most jurisdictions, any reference to your spouse is treated as if that person's died, treated as if that person's predeceased you. So the will still reads, but instead of all going to my spouse, Helen, I'm now divorced from Helen, we'll treat Helen as if she's predeceased me, and now it's going to go into my alternate plan. If Helen's predeceased me or doesn't survive me, then it's going to go this way instead. Having said all of that, the document after 20 years probably needs updating. It probably needs to be reviewed. So it's worth taking a look at it, because the chances of your distribution plan and your wishes, if you had children who were minors, you may have named guardians for them, set up trusts for them. They're now 25, 30 years old. It probably doesn't make sense anymore. The person that you've named as your executor probably doesn't make sense anymore. They may have health challenges of their own. So take a look at it. And even though your circumstances may not have changed, there's a good chance that there's people named in the will whose circumstances have changed. So we always recommend, and if anybody uses our service, we send them a reminder every year or two to say, you know what, you wrote your will with us. Take another look at it. Make sure it still reflects your wishes, because there's a good chance that it doesn't. So legally, absolutely. It's going to last you for the rest of your life. There's no expiration date on that document, but check it over, because there's a good chance it no longer reflects your wishes. So the next question we had was around married couples, and should a married couple do a will together or separately? So there are different approaches to this, and there are different types of will. A long time ago, traditionally, many will writers wrote joint wills. A will, one document that served two people, and there were a few reasons for that. Firstly, wills were being written by hand, and it was a hassle to write the same thing out twice. But back decades ago, there was this sense that everything you owned was owned by the family. Really, there was a sense that it was owned by the head of the household. There was this sense that not the both married partners were not equal asset holders. And to put it bluntly, there was a sense that a housewife may not have assets of her own. So that could be absorbed into a joint will. We don't do it like that anymore. That doesn't make sense anymore. And in fact, a joint will, one document serving two people, creates no end of issues. When one of the partners dies, you're left with one person being bound by the terms of a will that doesn't make sense to them anymore. So a lot of issues can arise from one document attempting to serve two people. I don't know of any will writers today that would attempt to write a joint will. It's just not done anymore. So there are different ways of doing handling couples. The most common is a reciprocal, or what we call at Legal Wills a mirror will. And fundamentally, it's two separate wills that reflect each other. If one person has named their spouse as their executor, then the other will would name their spouse as the executor. If one's the main beneficiary of one will, the other person's the main beneficiary of their will. They're opposites, if you like. Both wills have a plan in case the spouse doesn't survive them. So if my spouse doesn't survive me, then it's going to go to my children in equal shares, or it's going to go to this charity. There's a backup plan written into both wills. This is a mirror will. The key with a mirror will is they're not locked. They're not fixed. They don't have to be exact reflections of each other. Each will can be stand on its own as an independent document. If one of you wants to leave a charitable bequest in your will and the other partner doesn't, you can absolutely do that. You're free to make your distribution plan however you want. So the mirror will is not really a legal construct. It's more of a sentiment. They're like reflective of each other, but they're not legally bound in any way. As opposed to, there's a special kind of mirror will, which is called a mutual will. And a mutual will also includes an agreement that neither party or each party promises to never update their will once one of the spouses has died. Super complicated to do that. We really recommend not doing that, because again, your spouse could survive you by 30 years and they're bound by this will that makes no sense. They may remarry. And this idea of, I want to prevent my spouse from ever remarrying, it's kind of just, it's just distasteful, in my humble opinion. So a mutual will with a contract to never update it no longer really makes any sense either. Mirror wills, independent of each other, is absolutely the best way to go. At Legal Wills, we have a package. We have a couples package that allows you to quickly prepare a mirror will. I'm going to address one of the other questions that come in, and I think I can just add this here. Can you talk a little bit about the downsides of dying without a will, including such things as added government expenses, delays, complexities, establishing who the beneficiaries are, etc.? Yes. So the most obvious one that everyone talks about is the distribution plan, right? The distribution plan for your estate. Every province, every state has its own distribution plan for your estate if you were to die without a will. And in fact, no two provinces in Canada are the same, and few US states, even the UK, is different. And it's kind of weird. Like the distribution plan for dying without a will it's like a chunk goes to the spouse and then the remainder is shared between the spouse and the children. If you don't have a spouse and you don't have children, then it goes to your parents. It's usually not a distribution plan that somebody would create if they were writing their will. So it's just an odd approach to distributing your assets, and a little bit random. And one of the implications, actually, if you do have a spouse and children and you die without a will, and you assume that everything's just going to go to your spouse, that's not the case. It's a chunk's going to go to your spouse, but the remainder is going to be divided between your children, and your children may want some of those assets and may force the sale of some of your assets that your spouse doesn't want to sell. So that distribution plan is the most obvious hiccup. But the other really important one is the appointment of an executor. And this really comes to the fore when it's a parent with adult children and you have siblings, and the parent hasn't named an executor. So nobody's in charge at this point. The parent then dies, there's no will written, and nobody has been assigned the job of taking responsibility. The immediate aftermath is everybody just looking at each other. What are we going to do here? Who's going to start filing some paperwork? Oh, and by the way, Daddy promised me the painting over the fireplace, so don't mind. I'm just going to go in and help myself to that. And and Mom said I could have her jewelry, so I'm gonna take that. But there's no will, but she promised me that. So this happens all the time, where we get contacted from people and saying, my siblings just taking stuff out the house. Because nobody had the responsibility to secure those assets. Your executor's job is to not only get the ball rolling with the estate administration, but securing the assets and taking an inventory of those assets and making sure that the assets go to the beneficiaries that they're supposed to go to, written into the will. So that's one of the key challenges as well. Yes, it takes a long time. You have to prove that there's no will. Well, how do you prove that something doesn't exist? That's difficult. Then a person has to apply to be the estate administrator. That's a court appointment. Courts take time. It's a long, drawn-out process for the courts to get around to appointing an estate administrator. So all the while that this is being done, the assets are being locked down. Nobody can do anything. And that can even be a lockdown of assets that the spouse needs access to as well. So there's all of those logistical challenges as well. One of the most, the key groups of people who come to use our service are people who say, you know what? I've just dealt with my dad's estate. He didn't have a will. I'm writing my will today because I do not want to put my family through what we've just been through. That was an absolute nightmare. And I know that in the space of 20 minutes and half an hour, I can get my will written. And I just don't want to do this to my loved ones, die without a will. So people who have experienced this know it. They know the importance of writing a will. I'm going to touch on one more thing as well, which is a lost opportunity. Your will is a fantastic vehicle for showing appreciation for people and organizations who have touched you throughout your life. That can be charitable organizations, people who appreciate something that you have, like you may have a signed Jimi Hendrix guitar that your nephew just cherishes. Give it to your nephew. if you want to give $5,000 to your niece to travel the world, an education fund, you can do that in your will. It gives you the flexibility to do that and make a difference to a lot of people's lives. Social causes in your neighborhood, just leave 1%, 2% of your estate to those organizations. And it may be that you feel, I haven't been as charitable during my life as maybe I could have and should have. Things have been tight for me. Your will is a fantastic vehicle for recognizing different organizations and charities that may have touched you and your family throughout your life. So we only scheduled half an hour for this this live stream. So I think what we can do is I'm going to try and get through as many questions as I can and leave people wanting more, I guess, at the end of it. So if a property is jointly owned by a husband and wife, how is that treated in the will? So in most jurisdictions in Canada, the UK, and the US, there are two ways of jointly owning a property. You can own it as joint tenancy. You can own it as tenants in common. Most married couples own their property as joint tenancy. That means the full name is joint tenancy with the right of survivorship. That means the joint owner will automatically inherit the other person's share of that property. It goes to the surviving partner. It's not even a part of your estate in your will. It just immediately passes. It's not part of the estate administration taxes or probate fees or anything like that. That just goes to that other joint owner if it's joint tenancy. If you happen to own a property with your brother, you co-invested in a property, the chances are you own it as tenants in common, and you're absolutely free to leave your share of that property to whoever you wish in your will. So you can include that property either as part of your residual estate. It's part of your estate. It's calculated. I'm leaving everything I own to my two children in equal shares. Then that half of the property that you own as tenants in common is going to form part of that estate that you are going to be leaving to your children in equal shares. So I'm going to hit this one. Can I include property in a foreign country? Generally speaking, no. And we recommend that you don't. We recommend that you prepare a separate will for each country in which you hold assets. The reason being that if it does have to go through any kind of court administration process or probate process, that will has to be accepted by the local courts, property transfer agencies, whatever that department is in that country. The same applies to a power of attorney. If you have a bank account in Pakistan, there's no point in writing an Ontario power of attorney and having your power of attorney present that document to your bank in Pakistan. Then they're going to look at it and they're not going to know what to do with it. So the same really applies to a will. We recommend that you prepare a will for each country in which you have assets. At Legal Wills, we do cover Canada, the US, the UK, and South Africa. You can actually write multiple wills using our service. We have what we call an expat will service, where you can write your main will for the country in which you're living and the country in which you hold most of your assets. But if you are in a situation, for example, common in Canada, where you live in Canada, you have all your assets in Canada, but you own a condo in Florida, we recommend you prepare a separate will for that. You can use our expat will service to cover that condo in Florida. The two wills then work together. They don't revoke each other. They don't cancel each other out. So we're drawing to a close, but I'm going to cover this one. What options are available for getting a will witnessed? So most people who use our service, you can rely on any two adults. You sign your document in the presence of any two adults who have nothing to gain from your will. They cannot be a beneficiary, and in most provinces, they cannot be the spouse of a beneficiary either. Other than that, anybody can serve as a witness. There's no requirement. Everybody has a right to prepare their will. So there's no special requirement that says you have to use a lawyer, you have to use a notary, you have to use a justice of the peace to get this document done. You can get your will written, and you have every right to do that. So to make it a legal document, you need to sign it in the presence. I spoke about that recently. In some places, you can do it virtually, witnessing, but in the presence of two adults who are not benefiting from the document. They then sign it with those three signatures on the piece of paper. That becomes a legal document. There are services that do virtual witnessing. In Canada, we work with a company called Notary Pro. In the US, we work with a company called Blue Notary. They do virtual witnessing, and they will sit on a Zoom call and do the witnessing with you. That is an option. Let's talk about notarization specifically. You can, if you wish, get your will notarized. It can speed up the probate process if you do that. Absolutely. If you think somebody's going to challenge your will based on a claim that there was something wacky happened during the signing, have one of your witnesses sign what we call an affidavit of execution. They sign that in the presence of a notary. That's like swearing under oath, equivalent to doing it in a courtroom to testify that they were there at the signing and it was all done appropriately. We certainly work with okay. So actually, I just saw another question coming in about ASL. We'll see what we can do about that next time. I am sorry, we do not have an ASL. I don't even have captions. I should have put on captions. This is our first live stream. Next time, I'm going to put on captions for the live stream as well. So I can only apologize. We'll do better next time. So notarizing, we do partner with, again, Notary Pro, who can notarize your will. What happens is the witness signs the affidavit in the presence of a notary, and that is then attached to the will. We certainly recommend that with a power of attorney. Getting the power of attorney notarized, simply because some banks will only accept the power of attorney if it's been notarized or one of your witnesses has signed an affidavit in the presence of a notary. Banks can absolutely make up their own rules for what documents they're going to accept and what they're not. There's a legal standard for a power of attorney, and then there's individual banks that will assess their own organization's risk of allowing that person to serve as the power of attorney, and their perceived risk will determine whether they want to have that document notarized or not. So that's a half hour up. So I really hope this was useful. It certainly made me think that we might want to do this more often. I really sincerely appreciate people calling in on the live stream. My personal email address is tim@houston.ca. By all means, you can contact me if you do have some questions. I'm actually going to put this up. And put that up there. If somebody wants to contact me, actually, not that one. tim@legalwills.ca. Don't use that one. Don't use the other one. tim@legalwills.ca. If anybody does have any questions about legal wills, by all means, get in touch there at tim@legalwills.ca. I'll do my best to help. And failing that, if it's a question more generic or something about our service, by all means, you can contact us directly, our support team at support@legalwills.ca. More than happy to help answer any questions that you may have and help you get your will written. That's our mandate. We want to help you get your will written. So with that, thank you so much, everybody, for attending. I really appreciate it. And please get in touch, and we'll let everybody know when the next live stream is going to happen, probably in a